On a Tuesday evening, just after sunset, in a strip mall parking lot outside a hardware store in a quiet suburb, an electrician named Daniel was loading 2x4s into the open bed of his pickup. He hadn't done anything wrong. The truck was his. The wood was paid for. He was thinking about dinner. Then a marked patrol SUV rolled in slow, its lights off, and parked 2 spaces away. A uniformed officer stepped out, walked across the asphalt, and stopped about 6 feet from Daniel's open tailgate. "Mind if I ask you a few questions?" That was the line. Friendly, casual, almost neighborly. The kind of question most people answer without thinking. Daniel straightened up, wiped sawdust off his hands, and nodded. "Sure, what's up?" Before we follow Daniel any further, let's slow down for a moment, because what just happened in that parking lot is one of the most misunderstood moments in everyday American life. Right now, in parking lots, on sidewalks, and outside gas stations all over the country, this exact exchange is happening thousands of times a day, and the answer most people give is the one that gets them into trouble later. The line, "Mind if I ask you a few questions?" isn't a test of your innocence, it's the polite opening of what the law calls a consensual encounter. A consensual encounter is the lowest of 3 levels of police contact recognized in American constitutional law. The American Bar Association and police departments from coast to coast, including the Los Angeles Police Department's published policy, describe 3 tiers of police contact: the consensual encounter, the investigative detention, and the arrest. Each one carries a different set of rules, a different legal standard, and a different bundle of rights for you. The reason the wording matters is that your rights at each tier are dramatically different. At the consensual level, the tier Daniel was in, a reasonable person, looking at the whole situation, would feel free to walk away. No reasonable suspicion is required for the officer. No Miranda warning is required. The officer is free to ask you anything he wants. But you are equally free to answer nothing and walk to your truck. At the investigative detention tier, usually a Terry stop, the officer has specific, articulable facts that make him reasonably suspect you're involved in a crime. He can briefly stop you. He can ask you to sit in his patrol car. He doesn't need probable cause yet. He's gathering it. Once you've crossed this line, the rules shift. At the arrest tier, the officer has probable cause. He's taking you into custody. This is where Miranda almost always attaches, before any further interrogation. Daniel didn't know any of this. He nodded, and the officer moved closer. The officer's name tag read Martinez. Officer Martinez was polite, professional. He pointed toward the hardware store behind Daniel and asked, "You been in there tonight?" Daniel had. He said so. "Did you notice anything unusual near the garden center? Suspicious activity? Anyone loitering?" Daniel thought back. He had walked past the garden center. He had carried wood from the lumber yard. 3 men, dark jackets, mid-20s maybe. There's a guy who looked like he was watching the cash registers. Behind Daniel's head, a quiet alarm was already sounding. 3 men, dark jackets, watching cash registers. It sounded like a robbery pattern. He had just volunteered a witness statement in a case he knew nothing about. The officer asked another question. Were any of them Hispanic? Daniel hesitated. He didn't want to guess about ethnicity. He didn't want to put a description on a page. The more he said, the closer he was drifting from a casual conversation into the middle of an active police investigation. This is the moment most people miss. There's a simple phrase that lawyers, civil rights organizations, and police accountability trainers have taught for decades. It's not clever, it's not aggressive, it's not confrontational, it doesn't insult the officer. It simply asks a constitutional question that the law already provides an answer to. The phrase is, "Am I free to go?" That's it. Not "I want a lawyer." Not "I know my rights." Not "leave me alone." Those phrases sometimes come later. The first phrase, when you're unsure whether you're being detained or simply talked to, is the one that forces the question into the open. That question matters because of 2 amendments working together. The 4th Amendment protects you against unreasonable seizure. The Supreme Court has long held that a seizure occurs when a reasonable person would not feel free to leave under the circumstances. By asking the question out loud, you put the officer on the record. Either he says yes, in which case you may walk away calmly and immediately, or he says no, in which case you've just learned that you are now being detained, and every answer from your mouth has become part of an investigation. Daniel didn't ask. He kept answering. He gave a description. He gave a timeline. He even pointed in the direction he had last seen the men. 45 minutes later, Officer Martinez thanked him, took down his name and number, and told him to call if he remembered anything else. Daniel drove home. He slept fine. He never heard from the officer again. But what if one of those men had been questioned and identified a person matching Daniel's description, even slightly? What if the officer's notes had contained a small mistake, a misread time, a wrong color jacket? What if, 8 months from now, Daniel had been called as a witness in a trial where the defense attorney asked him, in open court, exactly which words he had used and exactly what he had seen? This is the long shadow of a single moment of casual conversation. None of it had to happen. The entire exchange sat from the first second at a tier where Daniel could politely have stopped it. So why do most people keep answering? Because the question felt harmless, because the officer was friendly, because Daniel, like most of us, is a person who wants to be helpful. None of that is the law is what it says it is, and it says you don't have to participate. Now let's unpack what the law actually says. The Fifth Amendment guarantees that no person shall be compelled to be a witness against himself in a criminal case. Translated into everyday life, this means you have the right to remain silent, and the right to refuse to answer questions that could implicate you even indirectly, in someone else's case. The ACLU's published guidance, the consensus of state and federal bar associations, and the Supreme Court's own framings all agree on one point. This right exists whether or not an officer has read you your Miranda rights. The Constitution annotated site run by Congress confirms that Miranda warnings only become required during custodial interrogation, after a person is in custody and officers want to question them outside of custody. The right to remain silent is yours by default. You simply have to use it. The Fourth Amendment, working alongside it, protects you against unreasonable seizure. Police departments across the country, including large departments like the LAPD, which publishes training material on this exact boundary, teach their officers to recognize the difference between a consensual encounter and a detention if the officer's actions, tone, repeated questioning, or physical positioning crosses that line. You have been detained, even if no one has called it a detention. Asking, "Am I free to go?" forces that question into the open. A footnote: the law school textbooks always include, even in a consensual encounter, there are situations in which a state may lawfully require you to identify yourself. In a 2004 decision called Hybel v. 6th Judicial District Court of Nevada, the United States Supreme Court upheld the constitutionality of so-called stop and identify statutes in several states. About half the states have some version of a stop and identify law. In those states, once you have been lawfully detained on reasonable suspicion, refusing to provide your name can, by itself, become the basis for a separate charge. So if an officer tells you that you are being detained and asks for identification, the answer depends on the state you're standing in. If you don't know whether your state is a stop and identify state or not, the simplest answer is still this: provide your identification when asked. If you are no longer free to go, but don't volunteer anything else. Now the second scene we want to look at, because it's even more common than a foot approach. A traffic stop. Daniel's wife, Maya, was pulled over on a Tuesday morning 3 months later for going 42 in a 35. The officer walked up to her window and asked for license, registration, and proof of insurance. She handed them over. Then he asked, "Do you know how fast you were going?" Most people, asked this question in the moment, respond with a guess. 42, maybe 44. The officer working radar is going to know I was a few over. Honest, polite, almost reflexive. That admission isn't required, and in some cases it has become the foundation of the citation instead of the radar reading. The officer's radar may have been imperfect. The officer's pacing may have been uncalibrated. But the driver's own words, captured on body camera, have now confirmed the speed. When the officer asks, "Where are you coming from? Where are you headed?" the same principle applies. You are not required to answer. Traffic stops are detentions under the Fourth Amendment and have been for decades. You must, in every state, provide your license and the documents the officer asks for. Most states also require proof of insurance. Beyond those documents, the right to remain silent is yours. If you want one phrase that travels well across most stops, it's still the same one. Am I free to go? On a traffic stop, the answer will usually be no, that's fine. The phrase has done its job. It's confirmed out loud on body camera that you understood you were being detained. After that, the second phrase is the one that protects you as the encounter escalates. I'm choosing to remain silent. I won't be answering any more questions without a lawyer present. That second sentence is well supported by every major civil rights organization as the cleanest way to put your decision on the record. It ends the casual back and forth that often produces evidence the officer didn't even need to ask for. Think for a moment about what you would have done in that traffic stop. Most people, honestly, would have answered the speed question. That's the whole point. The question is designed to feel easy, harmless, conversational. The right answer is the one most people don't think of until they've heard it explained. So what should you actually do if an officer walks up and says, "Mind if I ask you a few questions?" Step 1. Pause. The moment of pause is itself valuable. People under stress often answer the first question they hear. Most casual police encounters are designed to feel informal, just a conversation. The pause reminds your brain that this is not informal. This is the Fifth Amendment in motion. Step 2. Ask, "Am I free to go?" Out loud, in a respectful tone, so it can be heard. Step 3. Listen carefully to the answer. If the officer says yes, leave calmly. Say nothing else. You may be tempted to explain yourself, to be polite, to add "I was just loading wood." Don't. The officer has just told you that you are free to go. Politeness on the way out is silence. If the officer says no, you've just learned that you are being detained. You still have the right to remain silent. Decide whether you want to give your name based on the state you are in. Step 4. Once detained, state clearly, "I'm invoking my right to remain silent. I'd like to speak with a lawyer." Step 5. Do not consent to any search. "I do not consent to a search of my vehicle, my property, or my person" is a complete sentence. You don't need to explain why. Step 6. No arguments, no sarcastic remarks, no threats, no claims about your job, your family, your political beliefs. The more you talk in a detention, the more material you are putting into the officer's investigation, intentionally or not. Try this in your head. Imagine you're alone with an officer at the side of the road. He asks his third question. What would your next sentence be? If your answer is the sentence I just gave you, you're now operating inside your rights, not against them. A note about laws that vary. Not every state's rules are the same. Some states require you to identify yourself if you've been detained, others don't. Some states have laws limiting the length of a routine traffic stop, others don't. Some jurisdictions have stronger protections around recording police interactions than others. None of what I've said here replaces the actual rules of the state you live in. Procedures and statutes may differ depending on the state or jurisdiction, and they do shift over time, if you want to know specifically how the law works where you live. Spend an hour with the website of your state bar association or your local ACLU affiliate and read the actual statute. That hour is worth it. Now the last time we meet Daniel, he's standing outside the same hardware store. 6 months later, the same Officer Martinez is parked in the same spot. The lights flicker once, then go out. Officer Martinez steps out of his SUV, walks over. "Mind if I ask you a few questions?" Daniel sets down his load. He straightens up. "Am I free to go?" The officer looks at Daniel for a long moment. "Yeah, you're free to go." Daniel nods, walks to his truck, gets in, locks the door, and drives home. He still doesn't know what Officer Martinez was working on that day. He doesn't know if the men in dark jackets were ever identified. He doesn't know what an unrecorded witness statement of an innocent bystander can become when it drifts into a case file 6 months later. He just knows that he said the 4 words the Constitution gives him as a question, not because it always releases you. Some officers will tell you no, and you must understand that answer too. But because it tells you where you stand, it moves the interaction from confusion into clarity, and clarity is the thing you are entitled to under the law. The most important thing to take from this isn't a clever comeback, it's the understanding that you have rights at every level of police contact, and those rights include the right to ask, politely, whether the moment you are in is the moment you think it is. If you found value in this kind of educational documentary, consider subscribing. New videos like this come out regularly, and the comments under each one are usually thoughtful, because people who watch this content tend to take these situations seriously. If you have a story of your own about a moment like this, a question you wish you'd answered differently, or a question that surprised you, share it respectfully in the comments below. Other people will learn from it, and so will we. Take care of yourself, know what your state requires. And the next time someone in a uniform walks up and asks if they can ask you a few questions, you'll know exactly what to ask back.